This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So let me see if I can give you a quick update on what's going on with Parler suing Amazon Web Services. After the events of January 6th, Amazon told Parler that they had to fix their moderation system and explain how they were going to better moderate their website to remove violent content, or else Amazon was going to suspend their account. And then Amazon did suspend their account as of Sunday night the 10th at midnight. Their account was suspended, and here's what comes up now. It looks like Parler is finally finding another hosting provider because Amazon's not going to be putting them back up anytime soon. So Parler sued for damages as well as for a temporary restraining order, and here Bloomberg reports Parler fails to win quick reprieve with a lawyer new to technology. And so the story here is that Parler made a complaint. The complaint is the document of the lawsuit, but then also made a request for a temporary restraining order forcing Amazon Web Services to rehost their content, putting them back up on the publicly available internet through Amazon Web Services. And so I thought today we could react to the various things that they've said. This is not going to be a reading of the entire lawsuit like I normally do on this channel. We're going to look for things to pick and choose and sort of get the idea of what's going on. So here is the initial complaint. This will not be the temporary restraining order, but it is a civil action for injunctive relief and damages. Last month, defendant Amazon Web Services and something about Twitter signed a multi-year deal so that AWS could support tweets. Wait, what? I don't know why we're starting with that. Amazon provides services to Twitter, but what does that have to do with Parler? Okay, and Amazon Web Services only provides Twitter's new Fleets feature. That's it. That's what Amazon Web Services is used for on Twitter. So I'm super already wondering, why in the world are we talking about Twitter when this is a lawsuit? I mean, let me scroll back up here. I don't see Twitter in the caption here. I see Parler versus Amazon Web Services. I don't understand. Okay. When Twitter announced it was permanently banning President Trump, conservative users fled to Parler. The exodus was so large that Parler was the #1 free download. Yet last evening, AWS announced that it would suspend Parler's account on Sunday, January 10th at 11:59 PST. The stated reason for the suspension was that AWS was not confident that Parler could properly police its platform regarding content that encourages or incites violence against others. However, Friday night, one of the top trending tweets on Twitter was "Hang Mike Pence." But AWS has no plans, nor has it made any threats to suspend Twitter's account. This is not a valid legal argument, let alone a valid legal argument to make in the first page of your lawsuit. A valid legal argument would be, Amazon suspended Parler. Parler had a contract with Amazon. Here's how that contract was breached. And because there's irreparable damage being done to Parler, Parler has to be put back up on Amazon services and then otherwise compensated for its damage. That should be the opening paragraph, not, hey, look at how we're being treated unfairly because Amazon hasn't suspended Twitter because of a trending hashtag. Let me go one step further into that. What was the context? I keep saying this. Look at the details. Look at the context. Did Twitter say you should go to the Capitol building and hang Mike Pence? No. Twitter said, somebody else said, hang Mike Pence. And so Twitter is reporting basically through its search or trending feature that others are talking about it. They aren't saying you should go and do this act. They are saying, here's what's being reported in the news is that people were chanting this chant. Was Parler suspended from Amazon because people were reporting that at the Capitol riot, that phrase was being chanted? No, that is not why Parler was suspended. So why would you lead with that in your complaint? That's my first major reaction. So they go on, AWS's decision to terminate Parler's account is motivated by political animus. Okay, fair claim. I don't know how that's a legal claim, but fair claim, sure. It could be motivated by political animus. It is designed to reduce competition. What? Amazon does not have a speech platform. They are not terminating Parler so that they can better benefit their own service. But Parler makes the claim here that by eliminating Parler, Amazon has promoted Twitter, which I don't think that's what happened. I'm pretty sure that Amazon banned or suspended Parler because of a very specific set of violations. And even if it was motivated by political animus, I don't know how that's a Sherman Antitrust Act violation because they have to be in the same market. Amazon is in the market of providing services to Twitter and to companies like Parler who otherwise don't violate their rules. And that doesn't put them in the same market. Amazon themselves, or AWS, the company, because remember, these are all going to be different companies. AWS is probably not the exact same company as Amazon.com, the shipping company. They are related. They might be held by a parent company, but they're probably organized as two different companies. And I don't even really need to go into that. So for a Sherman Antitrust Act violation saying that Parler is in competition with Twitter and Amazon promoted one over the other, therefore Amazon is committing an Antitrust Act violation. No. Also, to have such an Antitrust Act violation, I believe you would also have to have the power to stifle competition. And I don't see how they have that power. A Parler can go to another host. So they seek a temporary restraining order, and they say that Parler contracts with AWS. So finally on page 5, we get to the actual thing I think we should have started with, that Parler contracts with AWS, and that there would have been some kind of contractual violation. And then they go right back to Twitter. They're really focusing their attention on Twitter here. I don't really understand this lawsuit at this point. Why are we so focused on Twitter? Wouldn't this be a contract violation, and wouldn't you be asking for injunctive relief for specific performance of the contract, citing irreparable damage to Parler because of a Amazon contract violation? So they're going back into Twitter and Twitter and Twitter and more Twitter and more Twitter, and Parler is a looming threat to Twitter, so AWS moved to shut down. I mean, this is basically what it says. Parler is a looming threat to Twitter, so AWS moved to shut down Parler. Got to look at the context, though. It was only after violations were alleged by Amazon, and so you would really need to look at the contract. And if we had the contract to look at, we would be looking at it. Oh, we do, because they provided it in Exhibit B. So here is the Amazon Web Services customer agreement, and if we go to the termination section, it says the term of this agreement will commence on the effective date and will remain in effect until terminated under this section. You may terminate this agreement for any reason, providing us notice. We may terminate this agreement for any reason by providing you at least 30 days notice. Okay, so Parler's complaint could be that they didn't get 30 days notice. I think we're going to see that later. Termination for cause, though. Either party may terminate this agreement for cause if the other party is in material breach of the agreement and the breach remains uncured for 30 days. So again, you could have an argument that there weren't 30 days given. For cause, we have the right to suspend under Section 6. Okay, so we need to look at Section 6. B, if our relationship with a third-party provider expires or terminates. Or C, to comply with the law or requests of government entities. So what does Section 6 say then? Temporary suspension. We may suspend your right to access or use our services immediately upon notice if we determine, so it's their determination, that your use poses a security risk to the service offerings or any third party, or could adversely impact our systems, or the systems of any other customer, or could subject us or affiliates or any third party to liability, or could be fraudulent. If you breach this agreement, if you are in breach of payment obligations, if you have ceased operation in the ordinary course of business, bankruptcy, liquidation, etc. So there does seem to be something there for a immediate suspension. Let's just review the rest of this document quickly here. So there's press reports and death blow at the worst time. These don't seem to be legal claims. This reads to me more like a press release. This is a complaint that reads like a press release. So then we go count 1 Sherman Act, saying that they have violated the principles of competition, basically. Actual injury to competition. But that's a really high standard and probably one that this complaint does not meet, because AWS is not in direct competition with Parler. Parler is in competition with Twitter. And there is no motivation for AWS, as far as I can see from this complaint or in real life. There is no motivation for AWS to ban Parler so that AWS gets more business from Twitter. AWS gets paid by both. That seems to be the best business idea. If AWS wanted to make more money, they would host both. Also, Twitter banned President Trump. What does that have anything to do with this lawsuit? It's not relevant. It doesn't make the claims more likely to be true or less likely to be true, which is the relevancy standard. So breach of contract, I expected this to be count 1. I expected this to be the lead story here, would have been the breach of contract. So yes, they're talking about the 30 days, and they're saying that only on January 8th did AWS bring concerns to Parler. This is what I expected to be the lead story here in this complaint, was the breach of contract and the 30 days. So there was no chance to cure and no uncured material breach for 30 days. So they should have had 30 days to cure. The immediate termination will make it impossible for Parler to have an online presence for at least a week, and apparently more, as we saw that their website is still down. Thus, AWS will breach its contract and harm Parler. Lost future profits are difficult to calculate. And then count 3, tortious interference with a contract. AWS will intentionally interfere with the contracts Parler has with its millions of present users. The defendant's interference must be for an improper purpose, though, so that's going to be the crux of that. That's going to be the issue there, is whether Amazon's termination is for an improper purpose under tortious interference law. And then they ask for a temporary restraining order. And then you can come over here and you can see the actual motion for the temporary restraining order. And a temporary restraining order has some requirements for it, but let's take a look at what they say. They ask for a restraining order, they reiterate many of the same facts, and they lead with Twitter on the first page. I mean, maybe not on the caption here, but on the first page of the actual text of the motion, Twitter is starting to be talked about. I do not understand why Twitter is this. It's like a child on a playground screaming that Johnny got a piece of candy, but I didn't get a piece of candy. There is some legal complaint there, and it completely misunderstands that Johnny's mother gave him a piece of candy and Parler's mother didn't give them a piece of candy. They're two different situations. Of course, the common element here they're alleging is AWS, but AWS doesn't have any different duty. It's the same duty. AWS, under the terms of the same agreement, as far as I know, banned or suspended Parler, asserting that it was for cause. Parler is saying, but Twitter also hosts speech that violates the AWS agreement. That's for AWS to determine, not for Parler to determine. And I didn't see a good faith and fair dealing claim in there either, which probably wouldn't work either, but at least that would be closer to something. This is a very tenuous lawsuit so far. You'll see Amazon's response in a moment, which I think will make a lot more sense. The stated reason for the suspension was that AWS is not confident that Parler could properly police its platform. And then they go back into the Hang Mike Pence thing that was trending on Twitter without giving any context whatsoever. In other words, what's the difference between reporting that the people who stormed the Capitol were chanting "Hang Mike Pence," and what's the difference when someone reports that it happened versus someone putting a post on Parler saying, "I want to," or "we should do that thing"? I bet you if you go onto Twitter and you say, "I'm going to," and then say those words, I bet you get suspended by Twitter as well. And isn't that what they're complaining about? That's what Amazon wanted them to do on their platform. If they had done that, it sounds like they wouldn't have been suspended. So they reiterate all the same stuff, basically, and ask for a temporary restraining order. Here's a part that they do get right. The standard for a temporary restraining order is a likelihood of success on the merits. I'm already questioning that one, but the harder standard is the likelihood of an irreparable injury. Then there has to be a balance of equities, a balance of fairness, and a public interest. So I'll just jump straight to Amazon's response. Amazon says, "This case is not about suppressing speech or stifling viewpoints. It is not about a conspiracy to restrain trade. It is about Parler's demonstrated unwillingness and inability to remove from the servers of Amazon Web Services content that threatens the public safety, such as by inciting and planning these things and those things happening to public officials and private citizens. There is no legal basis in Amazon's customer agreements to otherwise compel it to host content of this nature. AWS notified Parler repeatedly that its content violated the parties' agreement. They requested removal and reviewed Parler's plan to do so. AWS suspended Parler's account as a last resort. Despite Parler's rhetoric, its lawsuit is no more than a meritless claim for breach of contract. The facts are unequivocal. If there is any breach, it is Parler's demonstrated failure and its inability to identify and remove the violent content." So Amazon says that Parler conducts the absolute minimum of content moderation, that there was an agreement with AWS, and they go over the terms like we just did. They also have an acceptable use policy. The AUP in turn makes clear that AWS does not have to host content that violates the rights of others or may be harmful to others. So it's a basic breach of contract claim is really all that's going on here. Parler repeatedly violates the agreement. There's a whole bunch of nasty things here that I am not going to read, but you can see on your screen that were apparently statements made on Parler. Now, hang on. On the fairness issue, which is not necessarily a legal claim, but let's just address the fairness issue. If you said these things on Twitter, that would also be unacceptable, and Amazon could probably enforce the policy against Twitter too. If Twitter doesn't have a moderation policy, and Twitter does have a moderation policy and it enforces it. I posted a meme picture of one person pointing a gun at another, and that was considered to be violative of Twitter's moderation policy, and I had to click remove this in order to reinstate my account. So if that's happening correctly, then Amazon is enforcing its moderation policy and Twitter is enforcing its moderation policy and not violating Amazon's acceptable use policy. Whereas what Amazon is saying, and I'm not claiming that I know whether who's right and who's wrong here, but what Amazon is saying is that there was no such moderation policy on Parler, or at least not effectively enforced. So they go on to say Amazon exercises its right to suspend Parler's account, and they go into some of the details of the January 6th riots. They reinforce by saying the same thing, that Apple and Google terminated Parler's accounts for the same reason. Parler's CEO said that we should be operational within less than 12 hours of downtime if Amazon abruptly pulls our access. So, which is different because in the previous document they said that they needed a week. Parler filed its complaint for a restraining order January 11th. Despite speculation, Parler alleges no facts that could possibly support its claims for breach of contract, tortious interference, or violations of Sherman antitrust law. So temporary restraining orders are extraordinary and drastic. We already went over the standard. They cannot show a likelihood of prevailing because Amazon did not breach the agreement. Parler claims that Amazon breached by not giving 30 days notice, but it was Parler who breached by hosting content advocating violence and failing to timely take the content down. And we can disagree all day over what timely is and how much notice they need, but that's going to be the crux of the lawsuit here. The content AWS provided to Parler is representative of volumes of content that pose a security risk to others in direct violation of the user agreement or the acceptable use policy. Parler has admitted it has a backlog of 26,000 reports of content that violate its minimal community standards that it has not yet reviewed. Parler's own failures left AWS little choice but to suspend Parler's account. Parler's complaint is replete with insinuations that AWS has equal grounds to suspend Twitter's account and thus discriminated against Parler. But AWS does not host Twitter's feed, so of course it could not have suspended access to Twitter's content. So, like I said, AWS hosts Twitter's Fleets feature, I think, is all that happens. Twitter has apparently blocked the hashtag that was saying the thing about Mike Pence. So Amazon also goes into the tortious interference part, where the defendant's alleged interference is the exercise of a contractual right. The plaintiff has no reasonable expectancy and cannot assert an interference claim. Parler has not alleged any interference was for an improper purpose. Like I said, what did I say? I said it would be for an improper purpose, and so that's going to be the argument there. Then they go into the Sherman Antitrust Act. A Section 1 violation must plead enough factual matter to suggest that an agreement was made. But Parler does not claim that Twitter and AWS communicated about Parler, much less formed an agreement, like an improper pricing agreement or an improper competition agreement. So they didn't allege the claim beyond mere possibility, so it must be dismissed. They do not even plead the basic requirements of a Sherman Trust Act claim. It is very complicated, and I wouldn't expect someone inexperienced to be able to do that. And I don't know what plaintiffs' counsel's experience with that is, but I wouldn't just jump in and start making Sherman Antitrust Act claims. Also, they claim Section 230 immunity. The provider of an interactive computer service is immune for acting in good faith to restrict access to material that is excessively violent. And this is where Section 230 might be properly used, because it is only meant for civil cases. It doesn't protect against criminal liability, and it's not for intellectual property cases, and that's not what's being alleged here. They're saying that they took down offensive content that was restricted in good faith. And they are an interactive computer service, so they can do that under Section 230. That is precisely what AWS did, removed access to content that it considered excessively violent and harassing. Then there's the balance of equities and public interest. I'm just going to skip over that. And then there's the irreparable harm section, which is this is the weirdest part, because what is the irreparable harm? In other words, what harm could not be repaired by money damages? A TRO is not warranted because Parler has not shown irreparable harm is likely. Irreparable harm is harm which cannot be redressed by a legal or equitable remedy following trial. Monetary harm is not an irreparable injury. Parler has not identified irreparable harm. AWS has promised to preserve Parler's data and help Parler migrate its services elsewhere. Parler's CEO has acknowledged that the service never relied on AWS exclusively. He also told Parler users the service will be operated within 12 hours of AWS's suspension. So therefore, a temporary service interruption is not irreparable harm, and any alleged harm would be compensable by damages. So AWS could pay for the money damages if they are liable. Of course, they don't think they're liable. So Parler has replied, and I'm not sure that there's a lot to go over here. They continue to double down on the 30-day notice requirement. They claim that AWS breached the agreement, and they continue to claim 30 days, which I think it was an immediate suspension notice. Was for the violent content or content that harms users or others. This, again, reads like we don't like what happened, so we're going to make a legal claim, not we have a valid legal claim. It goes into President Trump's banning from Twitter. Parler says that it was going to quickly identify and remove problematic content. It would later adopt an artificial intelligence system to pre-screen inappropriate content, which had shown promising initial results. But again, they didn't implement that yet. You need to implement that stuff and then make your website public. Parler says it had nothing to do with the Capitol riot. Okay, but the content that we saw back in the AWS opposition here doesn't seem to require a connection to the Capitol riot. They do say that Ashley Babbitt did have a Parler account but hadn't been using it since November. Okay, great. I don't think that those were the only reasons that the account was suspended. I don't think that was even what was said in the examples. And they again double down on the 30 days notice, triple down, quadruple down. And then they go back into pressure from progressive employees. So it's politically motivated and it's unfair because they didn't do the same thing to Twitter. And then they go back into their other arguments. So yeah, that's kind of a strange lawsuit. It seems like it is a lawsuit that is politically motivated and not a claim that is well grounded in some sort of legal, meritorious, remediable claims. It sounds to me like the most that Parler has is a basic breach of contract claim, which will turn on what the motivations of Amazon were to suspend Parler's account, whether they had to give 30 days notice, and whether their motive for doing so was an improper purpose or not. And that's really it. If Amazon can show that there was content being hosted that was in violation of Amazon's acceptable use policy or falls under Section 230 of the CDA, I don't see how Parler is going to be able to sustain the matter. Very interesting here, though, Parler moved for the temporary restraining order on the 11th of January, and Amazon nearly immediately replied on the 12th. So there was no waiting for a judge to schedule some sort of ex parte hearing. Judges don't like ex parte hearings or hearings without the other party. And so the judge said, no, we're not going to move that quickly. We're not going to force Amazon to reinstate Parler's account. We're not going to force Amazon to reinstate Parler's account. And they're going to have a hearing on the temporary restraining order. The judge will grant or not grant the temporary restraining order, and I'm assuming Amazon will file a motion to dismiss at some point in the future. It has 21 days to respond when it is served, 60 days if it signs a waiver of service, so one of those two time periods should apply when we know when Amazon has been served. I'm assuming it has been served, and so we should have some kind of motion to dismiss from Amazon to go over shortly. So keep it civil in the comments. We're going to have to moderate your comments if it gets out of hand. And I will ban people who say super inappropriate things. So don't do that. Just keep it to a meritorious discussion of the merits of the case. All viewpoints are welcome, but those viewpoints must be expressed in a constructive manner. And I too will be heavily moderating the comments that get out of hand. So let me know what you think about that in the comments below. Thank you for watching. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program, here on YouTube, also on Floatplane, and on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern. Our channel is community supported by your monthly financial contributions on patreon.com/ljfrench, sponsors.com/law, through YouTube membership, and through Floatplane subscriptions. Thank you to the following $50 plus supporters in the month of January: Joe Tyson, Mitchell Rowton, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Andy, Benjamin Hitov, Goliath Cleric, Ugly Grill, Shielo T, Rudolph Bescherer Jr., Oscar the Phrophet, HotGrillsInYourArea, Torpedan, Brandyn Abel, Cassandra Curran, Sovereign Tittizen, ShadowTycho, RDHDragon, Earthbound Star, Nathan McCarty, and Awful Asses with Lemon Fresh. And thank you as well to the $5 plus supporters who are scrolling on your screen. I hope everyone has a great week. I will see you in the videos that drop. I love you all. Bye.